Episode 5.7 Exceptions to Privilege and Work Product. As you know, the attorney-client privilege and the work product doctrine are evidentiary privileges that respectively protect certain communications between attorneys and their clients and materials created by attorneys in preparation for litigation. Both the attorney-client privilege and the work product doctrine provide strong, but not absolute, protection against compelled disclosure of protected information. Specifically, the attorney-client privilege and the work product doctrine can both be waived, and both are also subject to certain limitations which are intended to prevent misuse of the privilege. In particular, the crime-fraud exception provides that the attorney-client privilege doesn't protect communications in furtherance of a crime, and the work product doctrine doesn't protect materials prepared in service of a crime. Furthermore, communications and materials that implicate attorney misconduct may not be protected. Obviously, the owner of an evidentiary privilege can intentionally waive privilege, but what about an unintentional waiver? For example, does the inadvertent disclosure of a document to an adversary or third party waive privilege in that document? While waiver rules vary from jurisdiction to jurisdiction, the Federal Rules of Civil Procedure and Federal Rules of Evidence provide that inadvertent disclosure generally does not waive privilege. However, waiver or compelled disclosure in one proceeding may destroy the privilege in other proceedings as well. Courts tend to interpret waiver narrowly. Even if a party waives privilege with respect to some elements of a communication, privilege can still protect the rest of the communication. For example, the intent to disclose some elements of a communication may waive privilege with respect to those elements, but not with respect to other elements. Accordingly, even if some of the information in a document is not privileged, the document itself may be privileged. The crime-fraud exception provides that the attorney-client privilege and work product doctrine do not protect communications and materials that are in furtherance of a crime. In other words, otherwise privileged communications and materials are not privileged if they were intended to aid in future criminal conduct. However, information about past criminal conduct is not affected by the crime-fraud exception. So if a client communicates with an attorney about past criminal conduct, the communication is privileged. And if the client asks whether future conduct would be criminal, it is privileged. But if the client asks for advice about committing criminal conduct in the future, it is not privileged. Of course, how does one know whether the crime-fraud exception applies? If the communication or material is privileged, then it is protected from disclosure, and the court cannot evaluate it. But if the court can review all communications and materials for evidence of future criminal conduct, it would eviscerate the privilege. Accordingly, the requesting party typically must provide a reasonable basis for belief that the crime-fraud exception might apply, at which point the court can review the information in camera.